we have three eminent jurists with us who have agreed to take some time out of their schedule to encourage us and judge today's competition. Our first judge is Honorable Miss Justice Rekha Palli Ma'am, sitting Judge, Delhi High Court. Ladyship obtained her LLB degree from Campus Law Center, Delhi in 1986, was enrolled as an advocate with the Bar Council of Delhi in July 1986. Ladyship commenced law practice in 1986 in Punjab and Haryana High Court and practiced there till March 1989. Ladyship was also registered as an AOR with the Supreme Court of India in March 1991, practiced primarily in Delhi High Court, Supreme Court, and other judicial forums, including CAT, Armed Forces Tribunal, National Company Law Tribunal. Ladyship was appointed as the Standing Counsel of High Court of Delhi, Employees State Insurance Corporation, and A4 Schools, and was also appointed as Senior Panel Counsel of Government of India in the High Court of Delhi. Ladyship has represented various universities and municipal corporation in the Supreme Court. She was designated as senior counsel by the High Court of Delhi in April 2015. Ladyship was elevated as judge of High Court of Delhi on 15th May 2017. Ladyship is an example, has set an example of empowering women, and her work also speaks for that. In the year 2010, at the time when the ladyship was a member of bar, had represented the petitioner in the landmark case of Babita Punia case, wherein it was held that women army officers were also entitled to permanent commission in the army. In the very recent judgment, Honorable Supreme Court of India upheld the said decision of the Honorable High Court of Delhi. One more case I would like to highlight is a decision passed by ladyship last year in the month of December. In that case, wherein ladyship held that a woman fighting a domestic violence case cannot be evicted from her shared household, which she has been sharing with her husband and her in-laws, even if the property belongs to her in-laws, till the time she was provided with alternate accommodation. Such judgments of your ladyships has given power to women, and I would like to thank your ladyship to be with us today. Thank you. Our second judge is Honorable Mr. Justice A.K. Pathak, former Judge, Delhi High Court. Your Lordship was enrolled in the year 1980 with the Bar Council of Delhi, practiced in Supreme Court of India, High Court of Delhi, National Consumer Dispute Redressal Commission, MRTP Commission, and other forums between 1980 to 1995. He was on the panel of Delhi Electricity Supply Undertakings and Government of NCT Delhi. He was handling cases in Delhi High Court during 1994-1995. He joined the Delhi Higher Judicial Services on March 1995. He worked as a presiding officer, Debt Recovery Tribunal, Delhi from April 2000 to January 2001. So your Lordship was also presiding officer of Employees Provident Fund Appellate Tribunal from November 2004 till November 2005. Lordship also worked as a Registrar General of the Honorable High Court of Delhi from 28 February 2006 to 6 January 2007. Your Lordship was appointed as Additional Judge of Delhi High Court on 14th May 2009 and became a permanent judge on 5th September 2013. Your Lordship retired on 10th July 2019. We have a lot to learn from your Lordship, and I thank your Lordship for being here. Thank you so much, sir.
I would you one thing, if I can interrupt you. I would have been happier if you had done the introduction of Justice Pathak before my introduction. I was not.
No.
I would have been happier.
Protocol
Next time be a little careful. No, sir. That's
protocol has.
No, you don't forget your manners and courtesy. It's not fair. I didn't want to interrupt you, but next time be a little, at least from.
Yes, I'll take care for that, sir. Your Lordship.
He has gone as per the protocol.
Sir, that's not. That is not our Sanskriti. That's all I can say.
I know. Thank you.
And this is a ADHIVAKTA process. They are talking of Sanskriti, so they have to remember who's senior. Sorry, young man, but I had to say that.
No problem, ma'am. I will take care for that. Sorry. Shall I continue, ma'am?
Yes, of course.
Thank you. We have our third judge for today is a very senior member of bar and very respected member, Mr. VIKAS PAHWA, senior advocate. Mr. Vikas Pawar, sir, is a third generation lawyer practicing in Supreme Court of India and Delhi High Court. He was primarily he deals in primarily deals in criminal law litigation. He handles cases in criminal law like Anti-Corruption Prevention of Money Laundering, Narcotic Drugs and Psychotropic Substances Act, Foreign Exchange Violations, Serious Fraud Investigation Office cases. Mr. Pava successfully prosecuted Maruti Suzuki India Limited Manesar factory Royd case, in which the general manager HR of the company was burnt alive and 90 employees of Maruti Suzuki were severely injured. Mr. Pava is appearing for pro bono for association for the victim of Upar tragedy, in which 59 people died due to fire in a cinema hall in 1997. Mr. Pava is also appearing pro bono in Supreme Court of India for the victims in the case of Meerut fire tragedy, in which 64 people died. I thank Mr. Pava as well to be with us and bless us. So I am just saying the rules to your lordships and the participant. There'll be two teams. The team codes are 510 and 550. Each team will be given 45 minutes. There'll be two speakers in each team. They'll divide time among themselves, and they'll keep time for the rebuttal as well in that 45-minute period also only. It is the discretion of judges. If they want, they can extend time for a period of 10 minutes for each team. Memorials are with your ladyship and your lordship, and with your permission, we can commence the session.
Yes, please.
With the prior permission of your lordships, may the council intimate the time division between the two speakers speaking on behalf of state in the present case to the courtroom in charge?
Madam,
Yes,
before
please.
you start, can I ask one question to my friend? Do you have a score sheet or something which you can share with us? Please tell us the pattern.
Sir, I have WhatsApp. Archana ma'am has WhatsApped
It's
it to
already
you.
been sent. It's already been sent to us.
Okay, but I have not
I think
received
you
it.
missed it somewhere. Maybe we'll send it to you again. It's there.
So please confirm. Otherwise, I'll get it sent it again.
Okay. Yes, I've received it on my WhatsApp now. I've just got it.
All right. Thank you, sir.
Okay. Sir, do you have Justice Pathak? Do you have the mark sheet, sir? The mark
Because I'm doing from mobile only, so I don't think I can check up. But I might have received. Archana is in touch with me, so she must have.
All right.
Team 550 is the first team.
With the prior permission of the bench, may the council intimate the time division to the courtroom in charge? Much obliged, your lordships. Your lordships, the speaker 1 for team 550 representing state would be taking 22 minutes, and my co-counsel would further be taking 22 minutes, and we have reserved 1 minute for the sir rejoinder. Your lordships, with your due permission, may the council begin with the formal argumentation. Much obliged, your lordship. Good morning to the honorable bench. This is the council appearing on behalf of state in the case of State of NCT of Delhi versus Ashu. The council shall be dealing with issue 1 and issue 2 pertaining to the respective sections of Indian Penal Code and Arms Act, whereas my co-counsel would be dealing with issue 3 and issue 4 pertaining to the relevant section of NDPS Act. Your lordships, if the bench is well versed with the facts of the case, may the council begin with the formal argumentation. Much obliged, your lordship. Your lordship, under issue 1, the prosecution counsel humbly submits that accused is guilty for committing murder under section 302 of Indian Penal Code. Your lordship, since the case in hand has no eyewitness, the prosecution counsel shall be placing reliance upon the circumstantial evidence present in the case and putting forth a three-pronged argument. Firstly, the accused was last seen with deceased. Secondly, the actus reus of murder can be attributed to the accused in present case. And thirdly, the mens rea of murder is established in the present case beyond reasonable doubt. With prior permission of your lordships, may the council begin with the first prong of argument. Much obliged, your lordship. Your Lordship, the first prong of argument pertained to the last seen evidence. The last seen evidence, as have been an established principle, must qualify the twin test of primary test of proximity of time as well as distance, and both are being fulfilled in the present case. Your Lordships, the Prosecution Counsel will be placing reliance upon the camera footage recovered, the call detail records, and the retrieved chats for the same. Your Lordship, on page number 5 of the moot propositions, your Lordships may guide and attract their attention to the same. It is mentioned that SHO recovered a camera footage on 24th September 2019, and in the footage it was seen that accused was strolling in the vicinity of the flat. Your Lordship, the counsel is referring to page number 5, para 2nd. Your Lordship, further, the prosecution witness number 3, whom the camera belonged, in his statement appended to the moot proposition, which is available on the last page of the moot proposition under statements, page 31 of the moot propositions, your Lordship, the prosecution witness number 3, whom the camera belonged, told police that his house is located at a distance of around 300 to 350 meters, and he has several cameras facing the main road. Your Lordship, on the due perusal of the same camera recording, it was found that the accused in the present case was found strolling in the vicinity of the flat around the same time, which is the time span deposed by the postmortem report to be the time of murder. Further, your Lordship, in the same chain of argumentation, the call detail records on the location ID chart of the accused was retrieved. Your Lordships, on page number 5, para 2nd, it is noted that the call detail records and the location ID on the due perusal of the same, your Lordships, it was deposed that Ashu, who is the prime accused in the present case, called Sanjay on his mobile number, who is deceased number 1, on 21st, which is the date of incident, at around 7:59 p.m. Your Lordship, when accused was being summoned to give reasons for the same, he accepted the fact, which is mentioned again on page number 5 of the moot proposition, that he had called Sanjay. He accepted this and asked him to come downstairs, which further proves the fact that he was in close proximity of distance as well as time with the deceased on the date of incident. Your Lordship, in the same chain of circumstantial evidence, the prosecution counsel would further attract your Lordship's attention to the fact of the retrieved chats from the mobile phone of deceased as well as accused, which is available on the page number 5 of the moot proposition, your Lordship's second last paragraph. Your Lordships may attract their attention to the same fact that on due perusal of mobile chats, it was depicted that Sanjay, who is the deceased number 1 in the present case, as well as the accused, was in fact having drinks together at around 9:30 p.m. in the house of deceased. Your Lordship, there are further corroborating evidence to the effect that they were in fact having drinks together. First being the recovery of 5 black label bottles from the crime scene, which is available on page number 5, or page number 2, pardon your Lordship, on page number 2 of the moot proposition, that 5 black label bottles were recovered from the place of incident. Secondly, your Lordship, accused hair was also found on the place of incident, which have been testified by the forensic department, and the report of the same is available by the appendix attached to the moot proposition, page number 27, A16 collie. In the conclusion, in the conclusion of the forensic report, it is clearly stated that accused hair was found on the place of incident, which further confirms the fact that he was in close vicinity of the accused on the date of incident. Additionally, your Lordship, the fact that deceased have been intoxicated at the time of his death is also stated in the viscera report of the deceased, which is available on page number 4 of the moot proposition, your Lordships, para 3. It states that viscera stated that deceased was highly intoxicated, which further corroborates the fact that they both were in fact having drinks together on the date of incident. Hence, your Lordship, The last seen evidence relied upon the prosecution shows that accused have been in close contact with the deceased, both in proximity of time as well as distance, and since the deceased in the present case was found murdered within the same time frame, the permitted reasoning process would allow the Honorable Court to conclude that it was accused who had murdered him in the present case. Further, Your Lordship, such an inference can only be disputed if the defense counsel would tell otherwise what happened to the deceased till the time the accused in the present case was with the deceased. Further, Your Lordship, in the same chain of argumentation, the prosecution counsel would humbly submit before Honorable Court that circumstantial evidence present in the case shows within all human probability the actus reus can be attributed to the accused in present case. Your Lordship, in order to drive home the fact of actus reus, the counsel shall be placing reliance on the twin facts of the post-mortem report as well as the statement of witness and the disclosure statement made by the accused. Your Lordships, the post-mortem report available on page number 4 of the MOOT proposition establishes the causes of death for both the deceased in the present case. Your Lordship, the prosecution counsel feels obliged to assist the Honorable Court in guiding through the forensic report. Your Lordship, the major results of the post-mortem reports were the causes of injury, the causes of death for Sanjay, who is deceased number 1, was abdomen injuries. Secondly, Your Lordship, the cause of death for deceased number 2, who was Sanjay's mother, was injuries on neck. Additionally, Your Lordship, the probable time of death established by the post-mortem report was 44 hours plus minus 6 hours on the date of post-mortem, which when calculated comes to 11 a.m. to 11 p.m. on 21st September. Your Lordship, this is exactly the same time frame which prosecution counsel in her previous submission have deposed that the accused was in vicinity of the deceased. Further, Your Lordship, the fact of injuries caused to the bodies of deceased can be corroborated by the statement of prosecution witness number 1, who is the milkman in the present case and was first to discover the both bodies of deceased from the place of incident. Your Lordship, the same is available on page number 1 of the MOOT proposition. Last paragraph, Your Lordships may attract their attention to the same fact that Sanjay's body, who is deceased number 1, had several stab injuries in the abdomen, which is the cause of death deposed in the post-mortem report as well. And secondly, Your Lordship, with respect to the mother, there was a gunshot injury on the neck, which is established to be the cause of death for mother in the post-mortem report. Your Lordship, additionally, the prosecution counsel would also highlight the fact that the wound of mother, there was a blackening of wound around the gunshot injury found on the mother's neck, which is and the same fact can be perused from paragraph number 2, page 4 of the MOOT proposition. Hence, Your Lordship, the counsel have attracted attention of the bench to the nature of injuries so caused. Your Lordship, in the same line of argumentation, the counsel would now rely upon the disclosure statement which was made by the accused in the present case on 16 December. Your Lordship, on 16 December, after accused was arrested, due to the possession of white color substance later on deposed to be cocaine, he made a disclosure statement whereby he deposed the fact that he had caused death of mother with a country-made pistol, and same was recovered at the behest of accused from Nehru Park. Your Lordship, the accused in the present case did guide the police to the exact same location, which is a secluded place in the Nehru Park in present case, and a discovery of weapon was discovery of country-made pistol was done subsequently. Hence, Your Lordship, further, Your Lordship, the fingerprints of the accused was found on the country-made pistol, and same has been confirmed by the forensic department report appended to the MOOT proposition in under A16 collie. Your Lordship, the fact that accused was in close proximity, last seen evidence relied upon by the prosecution counsel, seen in chain with the accused himself making a disclosure statement, further leading to the recovery of murder weapon in the present case, and his fingerprints being present, proves beyond reasonable doubt that it was in fact him who had committed the murder. Further, Your Lordship, the blackening of wound around the mother's neck shows that it was fired from a short range, which could have only been done by the person who is present in the close proximity, which in present case has been established by the prosecution counsel was the accused. Your Lordship, additionally, with pertaining to the cause of death for Sanjay was abdomen injury. Your Lordship, on page number 4, it is Your Lordships may attract their attention to page number 4 of the MOOT proposition. It is given that station house officer in the due process of investigation seized a knife from the crime scene. Your Lordship, the same knife had blood of the deceased Sanjay, which have been corroborated by the forensic laboratory report in the present case. Hence, Your Lordship, the stab injuries were caused by the same knife recovered from the crime scene itself, proves that the accused had committed the murder and had the requisite actus reus for the murder in the present case. With Your Lordship's permission, may the counsel move to further submissions of mens rea. Much obliged, Your Lordships. Your Lordship, mens rea or guilty intention can be inferred as have been the settled principle by the nature of injuries caused and the circumstances from which the bodies were recovered. Further, Your Lordship, it is a settled proposition that every sane person intends the result that his action seeks to produce, and when a person hits other on the vulnerable body part, the intention to take life can be garnered from the same fact. Your Lordship, in the present case, the prosecution witness number 1, according to his statement noted, which is available on page number 1 of the MOOT proposition, last paragraph, last 5th line, that Sanjay's body had some stab injury. Your Lordship, the fact that the accused have inflicted several stab injuries on the vital organ or on the vital body part of abdomen proves beyond reasonable doubt that he had requisite mens rea and intention to kill the accused, to kill the deceased Sanjay in the present case. Additionally, Your Lordship, the gunshot injury has have been previously submitted, highlighted by the prosecution counsel, had blackening of wound, which shows, and blackening of wound, Your Lordships, is caused due to smoke, indicating that it was fired from very close proximity and within a short range. Your Lordship, the fact that the accused had had used the firearm from a very short range, and that too on the vital body organ of neck, proves in the present case beyond reasonable doubt that he had requisite mens rea to cause death of both the deceased. Further, Your Lordship, the mere knowledge that natural consequence of an act would be death is sufficient to attract liability under Section 302 of Indian Penal Code, as have been in the present case. Your Lordship, the Defense Counsel places its reliance upon the fact that there is absence of motive in the present case. However, Your Lordship, motive alone however, convictions alone could not be based upon motive. And moreover, in the cases where actus and mens rea pertaining to the intention of accused have been established by the prosecution beyond reasonable doubt, the motive is not of importance. Your Lordships, these were the submissions of the prosecution counsel pertaining to the issue of murder. With Your Lordship's permission, make the counsel move.
Madam, tell me one thing. Your own case is that the mother was trying to, the mother was trying to hit Ashu with a iron rod. Now, in that kind of a situation, if he retaliates just because whatever he has, he picks up whatever. Why will it not be covered under self-defense?
Indeed, Your Ladyship, the council understands your apprehension. However, Your Ladyship, the fact that mother had inflicted injury in order to save his son upon the accused is stated by the accused in his confessional part of the disclosure statement. Your Lordship, the disclosure statement as under Section 27 of the Indian Evidence Act, only that part of disclosure statement is admissible and is of evidentiary value which pertains to the recovery of weapon in the present case. And rest of the part comes under the confessional nature of the statement and which is barred under Section 25. Hence, Your Lordship, that fact that the mother had in fact hit and the plea of private defense can be discarded by the honorable bench in the present case.
All right.
What are the principles underlying the proof beyond reasonable doubt in a case of circumstantial evidence?
Your Lordship, the principle underlying, Your Lordship, in the case where there is no eyewitness, the prosecution counsel places reliance upon the circumstantial evidence. And the punch-sheet of proof of circumstantial evidence have been stated in the landmark case of Sharad Birdichand Sharda versus State of Maharashtra, whereby 5 principles were being being stated by the court. Your Lordship, in order to encapsulate the essence, the circumstantial evidence must form a chain of circumstances in the present case, which must be proved beyond reasonable doubt, and such circumstantial evidence must be conclusive in nature and rule out any other possibility of hypothesis being formed, which the prosecution counsel have tried to depose in the present case matter.
Madam, you have said that the principal evidence you have is of last scene evidence that you were seen together, and what evidence prosecution has collected is the CCTV recording. Now, we have seen the prosecution papers. There is no 65B certificate which has been attached. 1. 2, your own evidence suggests that the original, the primary evidence, the DVR has been destroyed. So how do you satisfy the court that this is an admissible piece of evidence in the absence of 65B and the primary evidence being destroyed already? There's an evidence recorded of the neighbor whose DVR was destroyed.
Your Lordship, the counsel shall be putting forth 2-pronged arguments to the 2 pinpointed questions Your Lordship has addressed. Your Lordship, firstly, with respect to the requirement of certificate pertaining to the electronic admissibility of electronic evidence have been rendered in Section 65B of Indian Evidence Act. Your Lordship, in the recent case of Arjun Pandit Rao Khotkar versus Kailash Kushan Rao Gondriyal, the Honorable Supreme Court had clarified the fact that in cases where all the efforts to obtain certificates went in vain, the requirement of certificate cannot be complied in. The honorable bench can rely upon the admissibility of such a evidence. Your Lordships, as you have rightly pointed out, that in the present case, prosecution witness number 3 in his statement said that his DVR got formatted. Hence, it could have there is no way that certificate could be obtained with respect to the same in the present case. Further, Your Lordship, the second point, the second question, if the counsel understood correctly, pertained to the electronic evidence of the pen drive in the present case, which was retrieved. Indeed, Your Lordship. Your Lordship, with respect to the same, Your Lordship, the pen drive, the recording was copied by the station house officer there and then only, and is available for the due perusal of the court and under seizure memo A7. Your Lordship, and further, the fact that he was seen in the close vicinity is not only based upon the fact of the camera footage itself. It is based upon other circumstantial evidence of the retrieved chat, as well as, Your Lordship, on the call detail records and the IDs. Further, Your Lordship, there are forensic evidence pertaining to the presence of hair of the accused in the crime scene. The fact that he was drinking together have already been corroborated by other evidences on record. Further, Your Lordship, with respect to the non-availability of certificate pertaining to the pen drive, the fact sheet is silent with respect to the same, and same cannot be drawn, and the same cannot be taken to be an adverse inference in the prosecution towards the prosecution.
The
Your
Madam, no, we've understood. Second question is, how do you connect the country-made pistol with the crime? Because you don't have a ballistic, opinion. The report is missing. Just because there are fingerprints of the accused on the weapon doesn't mean that it has been used, because the empty cartridges do not match with the country-made pistols. How do you connect the weapon with the crime?
Need your lordship, the council would feel obliged to answer your lordship's query. Your lordship, the present weapon in question is a country-made pistol. And your lordship, the country-made pistol by its design and the phrase country-made itself indicates that it doesn't function as a normal pistol, which can be corroborated by the ballistic expert. Further, your lordship, in the case of Chhattar Singh versus State of Haryana, the same infirmity was noted by the Honorable Supreme Court Division Bench of the Supreme Court, and it was stated that circumstances of non-obtaining of report of ballistic report in the case of country-made pistol cannot shake the prosecution case. Your lordship, in the same case, the facts were that a country-made pistol was recovered at the behest of the disclosure statement of the accused, and the ballistic would have a current case matrix and the matter before this honorable court. Your lordship, the bench itself highlighted that the country-made pistols are so designed and are so smoothened up by the process known as lapping that there is grave possibility that all the roughness is removed and the rifling marks could not be obtained. Hence, the requirement of ballistic report can be done away with in the case of country-made pistol. And this case was also followed in the case of state of Madhya Pradesh versus Dhara Singh. Hence, your lordship, going by the precedents in the present case also, since there are other circumstantial evidence to suggest with respect to the fingerprints, the disclosure made, and the further leading to discovery of country-made pistols, the same can be attributed to the accused in the present case.
Okay, thank you.
With your lordship's permission, if I have satisfied your lordships with my answers, may I move to issue number 2 of the moot proposition of the moot?
Yes, please.
Much obliged, your lordship. Your lordships, the issue 2 pertains to the section 27, 28, and 29 of the Arms Act. Your lordship, the prosecution counsel humbly submits that the charges leveled against accused are not erroneous in the present case, and he attracts liability under relevant sections of the Arms Act. Your lordship, the counsel had already made submissions with respect to murder, and in the current issue too, the reliance would be placed upon the circumstantial evidence so put forth, owing to the infirmity that there is no eyewitness in the present case. Your lordship, the first penal section attracted in the present case is section 27 of the Arms Act. In order to attract liability under section 27, it has to be examined whether the country-made pistol was used in contravention of section 7 of the Act, which is the present case. Your lordship, section 7 entails liability of a person who possesses or uses any prohibited firearm. Your lordship, the word possession refers to the conscious possession, as have been deposed in the case of Hari Kishan versus State. Your lordship, conscious possession pertains to the mens rea of the crime, as have been deposed humbly submitted by the prosecution counsel. That mens rea can be gathered from the circumstances of the case, nature of injury, body part where injury was inflicted, which in present case are vulnerable body parts of neck of the accused. Your lordship, further, it is highly improbable that he was not in conscious possession of the same in the background that he provided. Your lordship, sorry for the interruption. The counsel seeks for extension of time. If your lordship's permit, the counsel seeks for extension.
Yes, we'll give you 5 minutes more.
Much obliged, your lordship. The counsel would conclude her argument.
Justice Rekha Pillin, Justice Pathak, that'll be okay, 5 minutes? Or
Yeah, sure.
All right, fine.
Much obliged, your lordship. The counsel shall wrap up the arguments pertaining to Arms Act within the given time. Your Lordship, the conscious possession also can be attributed with can also be concluded from the fact that the accused that accused did provide the exact information about the place of hiding in the present case, which was the secluded area in the bushes of the Nehru Park, Your Lordship, which is available on page number 7 as well as page number 23 of the moot proposition as the part of his disclosure statement. Further, Your Lordship, the fact that it had been used have been proved and deposed by the prosecution counsel in the preceding issue pertaining to the actus reus. Further, Your Lordship, the counsel feels obliged to repeat her points to encapsulate the essence that the fingerprints of the accused was found on the country-made pistol recovered at his behest. This, read in with the circumstantial evidence that he had conscious possession of the same, attracts liability of accused under Section 27 of the Arms Act. With Your Lordship's permission, may the counsel move to the further section?
Yes.
Much obliged, Your Lordship. Your Lordship, Section 28 of the Arms Act penalizes a person for using or attempting to use firearm to resist any lawful arrest or to resist lawful detention. Your Lordship, in the present case, accused was under arrest when he was apprehended with a white colored substance later on deposed to be cocaine. Your Lordship, the fact that he was under arrest is mentioned on page number 6 of the moot proposition. First paragraph, last line states that he was arrested after apprehension of the white color substance later on deposed to be cocaine. Your Lordship, the fact that he had attempted to resist the same can be gathered from the difference on the medical reports of the two hospitals, first being conducted prior to him making a disclosure statement and later being conducted on the subsequent occasion of him making a disclosure statement. Your Lordship, on page number 6, paragraph number 3, it is stated that that Ashu's medical, when done at ABC hospital, there were no injury marks found on his body. Your Lordship, this was prior to him making a disclosure statement. However, Your Lordship, when on page number, Your Lordships may attract their attention to the fact mentioned on page number 7, second last paragraph, that when Ashu was taken to DDU hospital subsequent to him making a disclosure statement and leading to recovery of country-made pistol, there were several bruises marks found on inner part of his thigh, which shows that he had attempted to resist the lawful arrest he was into. Further, Your Lordship, the defense counsel allegates that there have been infliction of a custodial violence in the present case. However, Your Lordship, the prosecution negates such a claim on the part of defense by stating the fact that there is no custodial violence, which can further be corroborated that there was in fact no complaint of nausea, fever, or vomiting as have been deposed by the report of DDU hospital. Further, Your Lordship, no other injury marks was found on the body part of the accused, nullifying the claim of defense with respect to infliction of custodial violence in the present case. Your Lordship, further the council would submit her submissions with respect to Section 29 of the Arms Act. Your Lordship, Section 29 entails liability of a person of intentionally purchasing and delivering firearms from an unlicensed person. Your Lordship, the fact that it is Your Lordship, may the council pleads for extension of a minute to wrap up her argument.
Only 1 minute. Not you can't keep.
Indeed, Your Ladyship, much obliged. I'll wrap up my argument within the same time. Your Ladyship, Section 29 entails liability of a person who intentionally purchases firearm from an unlicensed person. In the present case, the fact that it is a country-made pistol, which is a prohibited firearm, itself is indicative of the fact that it cannot be acquired from a licensed person. Further, in order to substantiate her claim, The licensed sellers are allowed to sell only those arms which are manufactured by those companies holding manufacturing license under the arms route. If the seller itself is unlicensed, he cannot sell the arm which is manufactured under a valid license in the arms route. The fact, Your Lordship, that it is a country-made pistol itself is indicative that it had been procured, and this read in with the conscious possession as well as usage corroborates the fact that he had procured it from unlicensed person. Hence goes the submission with respect to Arms Act. It was honor arguing before the honorable bench.
What is your name, madam?
Your Lordship, I'm speaker number 1, team 550.
All right.
Much obliged, Your Lordship.
Thank you.
Good morning to the honorable bench. With the permission of the bench, may the counsel for state proceed with the charges formed under the NDPS Act against the accused?
Yes,
Yes.
Much obliged, Your Lordship. Your Lordship, the accused is charged with sections 21, 25, 27, 27A and 28 of the NDPS Act, Your Lordship. Proceeding with the first charge, Your Lordship, section 27 of the NDPS Acts makes the possession and consumption of cocaine illegal. Your Lordship, cocaine has been defined under section 2, clause 5 of the NDPS Act to be the methyl ester of benzoyl econine and its salts, or any such preparation which contains 0.1% of cocaine, Your Lordship. Your Lordship, according to the facts of the case on page 1, the prosecution witness 1 had stated that he had found a white-colored, unique-smelling substance lying on the table next to the sofa on which the deceased was found dead. Your Lordship, when this white-colored, unique-smelling substance was sent for forensic report, it was found to be cocaine with a purity percentage of 17.5. The report of the same has been provided on page number 26 of the fact sheet, Your Lordship. Your Lordship, this fact brings the matter under the ambit of section 27, clause A, Your Lordship. Further, Your Lordships, the Supreme Court in the landmark judgment of Gaunter Edwin Kircher versus State of Goa has provided the three important elements which need to be fulfilled in order to show prove the liability under section 27 of the NDPS Act, Your Lordship. Those three being, firstly, that there is a possession in small quantity. Nextly, there is a possession of narcotic or psychotropic drug in contravention to the provisions of the Act, Your Lordship. And finally, that this possession was for personal consumption, Your Lordship. Your Lordship, with reference to the phrase small quantity, the Supreme Court, the state has, through its order dated 19th September 2001 in the official gazette, has marked 2 grams to be the small quantity threshold for cocaine, whereas 100 grams for the commercial quantity, 20 grams for small quantity and 100 grams for commercial quantity, Your Lordship. Your Lordship, in the current case, the purity percentage of cocaine was found to be 17.5, thereby bringing down the pure cocaine content of the white-colored substance found in the deceased's home to be 3 grams, which is nearly equal to the minimum, the small quantity threshold set by the government, Your Lordship, thereby fulfilling the first element of section 27. Proceeding to the next element, that is possession in contravention to the acts of to the Act, Your Lordship, the accused has failed to prove to provide any license, authorization, or permit, and has also failed to prove that the cocaine in his possession was for any medical or scientific purposes, thereby bringing him in contravention to sections 21 and 28 of the Act, which will also be proved in further submissions, Your Lordship, thereby fulfilling the second element required under section 27. Finally, Your Lordship, possession for personal consumption, Your Lordship. Your Lordship, the accused and the deceased had met on the fateful night, which has been corroborated through three things. Firstly, the chats retrieved, the CCTV footage, and then the crime scene, Your Lordship. Your Lordship, the veracity and credibility of the chats and the CCTV footage has already been proved by my co-counsel during her submissions. Your Lordship, the crime scene had clearly shown that there were 5 black label bottles lying, and that the white colored cocaine was found lying on the table next to the sofa on which the deceased was found dead. Your lordship, this points to one of the forms in which cocaine is consumed, that is through snorting. To further corroborate, your lordship, the viscera report of the accused shows that he was highly intoxicated at the time of his murder, thereby further corroborating by the fact that there was indeed consumption of cocaine. Your lordship, with regards to the defense side's hypothesis that there was claim that there was no drug test, one needs to understand the limitations of drug tests when it comes to cocaine, your lordship. Your lordship, cocaine only has a half-life of only 2 hours. That means 50% of cocaine is the consumed cocaine is eliminated from human body within the 2 hours of its consumption, and further its other half-life becomes faster. Thereby, it makes it humanly impossible for the prosecution as well as investigating authorities to travel back in time and do a drug test and obtain that indeed the accused had consumed cocaine on the fateful night as well. Thereby, the prosecution has to rely on the circumstantial evidence and which has been provided by the counsel for state in the current case. Your lordship, since there is a link formed between the chats, the CCTV footage, the crime scene, and the viscera report, it goes on to prove that on the basis of circumstantial evidence that indeed the accused had been consuming cocaine with and the accused had been doing the same as well. Also, your lordship, as my co-counsel has dealt in her arguments with the theory of last seen evidence, it is beyond doubt that the accused had possessed cocaine and had consumed it as well, thereby fulfilling all the 3 necessary ingredients for his actions to fall under the ambit of Section 27, your lordship. If the bench is satisfied, may the counsel proceed with the next charge?
Yes, please.
Much obliged, your lordship. Your lordship, the accused is also liable under Section 27A of the NDPS Act on 2 grounds. Firstly, the accused had harbored an offender, and secondly, that the accused was indulging in illicit financing of trade and financing and trading of drugs, your lordship. Your lordship, as has been provided in the case of Riya Chakraborty versus State of Bihar, the term harboring, though not defined explicitly under the NDPS Act, the definition of the same can be borrowed from Section 52A of IPC. Accordingly, your lordship, the inclusive definition provides that harboring to include supplying a person with means and assisting a person among various other things, your lordship. Accordingly, your lordship, in the current circumstance, the accused was well aware about the deceased's addiction and had been supplying him with cocaine, your lordship. Your lordship, this fact has already been corroborated through the CCTV footage, the chats between the deceased and the accused, and the fact the deceased and the accused, and that and through the previous submissions, your lordship. Your lordship, since the accused is the brother-in-law of the deceased, he was in somewhat position to have sent the accused, the deceased, for either rehabilitation or could have informed the authorities about his addiction and him being an offender. But instead, your lordship, the accused had tried to capitalize on the deceased's addiction by supplying him cocaine instead. Thereby, your lordship, the accused was supplying him with the means, which is the cocaine in the current case, thereby fulfilling the condition required that he was supplying the offender, that is his brother-in-law, with cocaine in the current case, and thereby coming under the ambit of harboring as per Section 52A of IPC, your lordship. Next, your lordship, is that the accused was indulging in illicit financing and trading of drugs. Your lordship, financing is when a financier obtains some monetary or other gains in return. The same has been held in the case of Riya Chakraborty versus Union of India by the Bombay High Court, your lordship. Your lordship, financing would necessarily mean that there were some activities involved by the financier, some trading or some illegal business with respect to the same. Your lordship, trading in the current case can be proved from two instances. Firstly, that the accused was supplying the deceased with cocaine, and secondly, from the fact that on 16th December 2019, Your Lordship, the same has been provided on page number 6 and 7 of the fact sheet, Your Lordship. Your Lordship, the accused was waiting in his BMW in Vijayanagar market at 4 p.m. with 20 grams of cocaine lying in plain sight on the dashboard of his car, Your Lordship. This fact that the cocaine was lying in plain sight on the dashboard of his car shows that the accused was in active knowledge of the presence of the same, and thereby was in conscious possession of the contraband, Your Lordship. A similar circumstance has been found in the case of Bhola Singh versus State of Punjab, wherein the Supreme Court had held that such a circumstance indeed points to the fact that the accused, when waiting with contraband in plain sight in a car, is shown to be waiting to change hands with the drugs, Your Lordship. Also, Your Lordship, there has been conscious possession on the given the fact that the contraband was lying on the dashboard on plain sight shows that there was conscious possession on part of the accused. Thereby, it cannot be said that the contraband was planted on him, or that he was unaware of the existence of the same in his car, Your Lordship. Next comes the element of financing or the monetary gains, Your Lordship. The same can be understood from the fact that the deceased had a loan of 2 lakhs which he had to pay to the accused. Your Lordship, the accused had also met the deceased for the same purpose, that is for the repayment of that 2 lakh credit along with the supply of drugs on the fateful night, Your Lordship. Your Lordship, as per the facts of the case provided on page 7, on seeing the deceased's reluctance on paying back the 2 lakh rupees, the accused was enraged to such an extent that he went on to stab the accused, which eventually led to the deceased's murder. Your Lordship, the accused's reluctance and sudden anger at the fact that he was not going to get back his payment shows that there was indeed financial gains, financial transactions involved, which were very dear to the accused, thereby evoking such an anger on the accused's part, thereby fulfilling the condition of financing as required under section 27A, Your Lordship. Further, Your Lordship, it has been held that the quantity doesn't have a bearing when it comes under section 27A of the provision, Your Lordship. The same has been held in the case of Riya Chakraborty versus Union of India. Thereby, Your Lordship, it does not matter the quantity with which the accused was dealing in. Since it has been proved that the accused was indulging in financing and trading of drugs, thereby he attracts the penalty under section 27A, Your Lordship. To further substantiate, Your Lordship, as held by the Supreme Court in the case of Arun Kambli versus State of Goa, the burden of proof lies on the deceased and not lies on the defense and not on the prosecution when it comes to grave charges such as section 27 and 27A under the NDPS Act, Your Lordship. Your Lordship, the duty of the prosecution in such matters is to provide a reliable hypothesis pertaining proving the charges formed against the accused. The duty of the accused, Your Lordship, is to prove beyond reasonable doubt, and preferably through direct evidence, that indeed the accused was innocent and that the charges are futile, which the defense has still not done in the current case, either through their written submissions as well, Your Lordship. If the bench is satisfied, may the counsel proceed with the next charge, Your Lordship?
Something.
You continue, whether we are satisfied or not can't be said.
No, madam, only tell me, you have been repeatedly saying that because there was he's admitted in his disclosure that he had to take 2 lakhs from the deceased. So that makes it that there was he was financing the drugs or the transaction. How are you relating that? Just because he had to take 2 lakhs, how are you correlating that to financing?
I understand the question, Your Ladyship. Your Ladyship, it needs to be understood that the chats provided.
Is it not a presumption on your part that because he had to take, it could be for any reason whatsoever?
I understand, Your Ladyship, but Your Ladyship, it needs to be understood in accordance to the facts of the case that the chat which was retrieved by the police was what led to them to go forward and apprehend the accused, since it provided substance to the charges to be formed against the accused. The same was not possible with the CCTV footage only, since the chats had such cogent evidence that they were about the accused crimes, that they had gone ahead and apprehended the accused. Thereby, the prosecution is relying on these chats to come forth and provide this hypothesis that indeed the 2 lakhs had been for financing of drugs. And also, as the prosecution has provided, that the accused was enraged beyond to such an extent that he went forward to stab a person. This shows that the monetary gain which was required by the accused was such significant was so significant that he had
This is
no
all,
other option.
this is all inference, you see.
That's it.
Whether the another question, important question is whether a confessional statement which has led to, which you can say disclosure statement which has led to recovery of X item, whether whole you see disclosure you will read as or you will read only that portion which has led to the recovery. So that is another part. What do you have to say in that?
Yeah, indeed, Your Lordship, I understand the question. Your Lordship, disclosure statement only pertains to the fact which leads to discovery. And as in the current case matter.
So how you say that the statement that I had to take money and all that, can it be read? Apart from the something which has been recovered like your pistol or something. That is to be only read, not the whole thing. You see, all story has not to be read.
I understand, Your Lordship. However, we need not forget that there are chats corroborating this fact as well. And further, Your Lordship, the duty of the prosecution when it comes to charges under the NDPS Act is to provide a reasonable hypothesis and not prove everything beyond doubt, unlike other penal offenses, Your Lordship. Currently, the burden is on the defense to prove beyond reasonable doubt that the accused is innocent with respect to the current charges formed against him.
NDPS 6 is highly technical and the accused can be acquitted only on those technicalities or not fulfilling those requirements as contained in the NDPS Act. So where is the question of, you see, what do you have to say about drawing inferences?
Pardon, Your Lordship, if you could repeat the question.
I'm saying that NDPS Act is highly technical and accused can be acquitted on technical grounds.
Indeed, Your Lordship.
Of non-compliance of certain specific actions which are envisaged under the Act, like giving a notice to be searched, like giving information to the higher authorities. So all those section 20, I think 20, I'm not recollecting the exact sections.
Section 42 and
42, 41 and section 50.
So it is even if you prove everything but you fail in that, the whole case goes. So what do you have to say in that regard?
I understand, Your Lordship. The council would also be proving further that all the mandatory provisions, especially those under section 50, have been complied in the current case, Your Lordship. Right. However, to satisfy Your Lordship, may the council go ahead and state the same?
Yes.
Much obliged, Your Lordship. Your Lordship, section 50 provides for personal search, and accordingly, the mandatory provisions provide that firstly, the person to be searched has to be given a notice of him being searched, and secondly, he has to be made aware that he has a right to be searched before a gazetted officer or a magistrate, and thirdly, that such a person to be searched needs to be taken before a magistrate or gazetted officer as soon as possible and then be searched, Your Lordship. And Your Lordship, in the current case, the provisions have been complied with. Your Lordship, the accused was given due notice on 16th December 2019 by the investigating officers when he was searched while he was sitting in Vijayanagar market in his BMW, Your Lordship. Whereas no contraband was found on his person, but the contraband was found from the dashboard of his car. Your Lordship, it has been held in the case of State of Punjab versus Baljinder Singh, the scope of section 50 does not travel to when it comes to searching of vehicles. Instead, Your Lordship, section 51 becomes applicable in that case. So when a contraband or an evidence is obtained from a vehicle, it would still be admissible in the current case, even though all the mandatory provisions of all conditions of section 50 have not been fulfilled, since the section 50 only pertains to personal search, your lordship. Thereby the counsel for state humbly submits that since all the mandatory provisions and the technical provisions have been dealt with due cognizance by the investigating authorities, therefore the evidence produced should be admissible in the honorable court, your lordship.
Madam, just one question. You are saying that section 50 has been complied with. If you read section 15, the notice has to be given to the accused before search, whether he wants to get searched before a gazetted officer or a magistrate.
Indeed, your lordship.
The notice which you have served is an erroneous notice. You have only given him one option, that you can be searched before a gazetted officer. Please see page 6 on the top 5th or 6th line. So it's an erroneous notice under section 51. Second, you must understand that in special statutes where there's a presumption against the accused, it doesn't mean that you will start presuming everything and leave it on to the accused. It is a duty of the prosecution to prove the foundational facts of the case. When you prove the foundational facts of the case, only then the presumption will go to an accused. And in this case, your entire case is based on the disclosure. Please show us one independent evidence of this section number 27A, which you are saying you are harping, because it's a very serious offense, punishable for 10 years and up to 20 years. Now, where is the independent evidence of financing or harboring? You are presuming, just like the honorable judges have said, you're presuming. Please show us the independent evidence of harboring and independent evidence of financing. Only then you can ask the accused to rebut the presumption. So foundational facts have to be proved. And how the section 50 notice is legal in terms of the act?
The council understands the lordship's apprehension. However, your lordship, the council humbly submits that there are certain limitations to the current fact sheet, and the prosecution cannot travel beyond those facts or presumption or limitations, your lordship. Thereby, the prosecution is building its case on the available circumstantial evidence and the limited amount of facts, solid facts, which have been provided. And thereby, it would be wrong or erroneous on the part of the prosecution to present facts which are not given in the fact sheet itself to be foundational facts just for the sake of proving these provisions, your lordship. Therefore, the councils for state are trying to build a case on the basis of circumstantial evidence and trying to give a reasonable hypothesis to the honorable court, your lordship. May the council proceed with the next three charges, your lordship?
Yes.
Much obliged, your lordship. Your lordship, the accused is liable under section 21 for possessing, selling, and trading of manufactured drugs, your lordship. Your lordship, as held by Justice P.P. Navlekar in the case of E. Michael Raj versus Intelligence Officer NCB, the section 21 gets activated when the actions of an accused fall within the prohibited actions as provided under section 8, your lordship. Your lordship, section 8 of the NDPS Act prohibits any person from buying, selling, manufacturing, trading in narcotic or psychotropic substances, your lordship, without any license, authorization, permit, or any such reason which shows that it's for medical or scientific purposes, your lordship. Your lordship, as has been submitted by the council in its previous cases, your lordship, the accused was indeed in possession of cocaine, had been trading in cocaine, and had been consuming it as well. However, throughout the process of investigation, neither has the accused come forth and given any license or authorization making his possession to be legal, nor provided any substantial reason to prove that his possession was for medical or scientific purposes, your lordship. Thereby bringing his actions under the ambit of section 8.
Sorry to interrupt, your lordship and ladyship, the time is over for speaker 2, so kindly.
With the permission of the bench, may the council get an extension, your lordship?
How much time do you think you need now?
Your lordship, 3 minutes.
All right, 3 minutes we'll give you.
Much obliged, your ladyship. Your ladyship, since in the current case, the accused has failed to provide any such authorization, licensing, and neither has the have the investigation authorities come forth to retrieve such an authorization or permit, especially at the time when on 16th December, the accused was found sitting in his BMW waiting in Vijayanagar market, when he could have easily shown a permit or any such reason to prove that it was for medical or scientific purposes. However, the accused has not done the same, thereby bringing his actions under the ambit of Section 21, Your Lordship. Proceeding with the next charge, Your Lordship, under Section 25 of the NDPS Act, it provides that any owner of any space or enclosure, conveyance, animal, etc., is liable to be punished if he either knowingly permits the use of the same for committing of any offences, Your Lordship. The scope of this provision, Your Lordship, has been well laid down by the Rajasthan High Court in the recent judgment of Puran Ram versus State, Your Lordship. Accordingly, the court had said that from a bare reading of the language of the provision, it is clear for attracting the penalty under Section 25, the owner has to either use the property himself and knowing for committing offences, or knowingly permit the use of the same by some other person for committing offences under the NDPS Act, Your Lordship. And Your Lordship, as has been proven by the Counsel for State in her arguments, that the accused had been using his BMW for transporting of drugs and for exchanging hands on drugs, since the contraband, 20 gram of which was found from the dashboard of the accused's car, thereby bringing him under the scope of Section 25, Your Lordship, since the accused was well aware and was in conscious possession of the contraband in the given circumstance, Your Lordship. Finally, Your Lordship, the accused also attracts a penalty under Section 28 of the NDPS Act. Your Lordship, Section 28 penalizes both attempts to commit an offence as well as committing offences under the NDPS Act, Your Lordship. Your Lordship, the accused has already been found liable, has been proven liable by the prosecution for possessing, consuming, selling, purchasing and trading cocaine, as well as harboring an offender and indulging in illicit financing of trade, Your Lordship, of drugs, Your Lordship. Finally, when it comes to the attempt part, attempt has been defined under Section 511 of IPC, Your Lordship, which has three major elements, which are, firstly, that there needs to be a proper mindset to commit a crime. Secondly, the accused must have put in methods and means for achieving the crime, for achieving the objective. And finally, the accused must have failed to do the same. Your Lordship, when the investigative authorities apprehended the accused in Vijayanagar market, since we have already known that he was in conscious possession, therefore the intent part of the requirement is proved. Secondly, since he was waiting in his car with the contraband, it shows that he had all the means and methods ready to do the deed, because it's a very good disguise to be sitting in open in a busy market, because nobody would be suspecting that a person would be sitting with contraband in plain sight. And finally, since he was not able to exchange hands with the contraband, therefore he has fulfilled all the three elements required under Section 511, Your Lordship. With the permission of the bench, may the counsel proceed and submit the prayer, Your Lordship? Much obliged, Your Lordship.
Madam, just a minute. I think you must realize the importance of a prosecutor. Prosecutor has to be independent. Prosecutor has to be careful when the charges are being framed, or even when he's arguing the matter before the court. In your exuberance, you are trying to invoke all sections which are not even remotely connected with the crime. Take, for instance, Section 25, which you're talking about. 25 is an offense, again, which can be, in which a person who's an owner of a vehicle can be implicated when he lets someone else to use the vehicle. Now he himself in his own car is found with the contraband. How can Section 25 be made out? Please use. It is said knowingly permits it to be used for the commission by another person. So 25 is not made out. Same 511. Out of exuberance, you are saying 511. 511 is an attempt to commit an offense under the code. IPC 511 cannot be used with NDPS Act, because abetment and attempt is a separate offense in NDPS. So prosecutors have very large responsibility, and it's a very sacrosanct duty No, you have to be independent. You're not a mouthpiece of the NCB in this case or any other state. So be careful when you are putting a charge against a particular person. Don't just charge him just for the heck of it. You have to substantiate it.
Indeed, Your Lordship. So, may the council put forth, reiterate her arguments to satisfy the judge with
No, no,
respect
not,
to
Heard
these?
you.
not,
Heard you.
not,
Heard
not,
you.
not in
We
this
are just
point.
making an observation because we heard you and we have seen that these offences are not made out. At least the last two which I have mentioned straight away.
Indeed, I understand your lordship, but with respect to scope of section 25, your lordship, the council has already put forth the judgment of Rajasthan High Court Puran Ram versus State, wherein the scope of section 25 had been laid down by the Honorable High Court, wherein it also included that the owner may be himself using his property for commission of offences or allowing another person for committing the same. Thereby relying on this precedent, Your Lordship, since it's a 2019 judgment, the prosecution has tried to put forth the charge under Section 25, Your Lordship.
All right.
Thank you. We've heard. Thank you.
May the council proceed with the prayer, Your Lordship?
Yes,
Madam, your time is up. Now we know your prayers. You're wanting him to be charged under all the sections.
Yes. So
That-
let us go, next.
but
Next.
if you're dropping a section, you can continue. But if you're not dropping, then we have heard you.
yes, that's what I said.
Your Lordship, the council won't be dropping any charges
All right,
against
then
the
we know your
accused.
prayers. It's all right. Thank you, madam.
Thank you.
Much obliged, Your Lordship. It was an honor to submit the arguments.
Your Lordship and Ladyship, the prosecution arguments are complete. Shall we proceed with the defense argument
Yes.
with your permission?
Yes.
Team 510, please.
Am I audible?
Yes, you are.
Thank you. To the bench, your lordship and your ladyship. This is the counsel on behalf of the defense, representing Mr. Ashu in the matter of State of Delhi versus Ashu before the Honorable Special Sessions and District Court, Delhi. Your lordship and your ladyship, my client was falsely charged by the investigating team under sections 302 of Indian Penal Code 1860, under section 21, 25, 27, 27A and 28 of the NDPS Act 1985, and under sections 27, 28 and 29 of the Arms Act 1959. Your lordship, the cardinal principle of criminal jurisprudence itself states that it is the job of the prosecution to prove the guilt of the accused beyond all reasonable doubts. The job of the defense is to only bring forward the loopholes in the version presented by the prosecution. Your lordship, the counsel for the defense are sympathetic towards the family of the victims, but this shorty investigation has made a joke of their sufferings, and my client cannot be punished and forced to suffer further on the basis of such a messy investigation. Your lordship, I shall be putting forward arguments disproving the charge of murder under section 302 of Indian Penal Code 1860, while my co-counsel shall be disproving the charges under the NDPS Act and the Arms Act. Your lordship, if there are no preliminary queries, the counsel seeks permission to proceed with the arguments. Much obliged. Your lordship, the accused is not guilty of the offense under section 302 of for the murder of Sanjay and his mother. The arguments of the counsel shall be threefold. First, there is an absence of intention or knowledge relating to the commission of murder. Second, the faulty investigation will result in the prima facie exoneration of the accused. And lastly, the evidences in the present matter suffer from a number of infirmities. Your lordship, beginning with the first submission, and before starting with the submission, the counsel would like to summarize the whole case of the prosecution. Your lordship and your ladyship, the whole case of the prosecution on charges related to section 302 was based on CCTV footages, the CDR and location ID chart, and the disclosure statement of the accused. The counsel will prove that all of these three evidences suffer from so many infirmities that they cannot be relied under any circumstances whatsoever. Your lordship, there is an absence of intention or knowledge relating to the commission of murder. The crux of every case under section 302 is the intention of the assailant. In the case of Jaswant Singh versus State, cited at footnote number 9 on page number 19 of the memorial from the defense, the Honorable Supreme Court of India held that intention to kill is the most important ingredient of the offense under section 302. And if this is not proved, no conviction can be held, even if the act committed is sufficient to cause death under normal circumstances. Your Lordship, in the present case, there is an absence of any intention on part of the accused to murder Sanjay and his mother. The investigating team has failed to discover any evidence or any possible reason because of which the accused might have killed the victims. Further, the investigating team has also failed to find out any fight or ruckus between the accused and the victims. Further, Your Lordship, in the case of Anil Rai versus State, cited on footnote number 15 on page number 20 of the memorial from the defense, the Supreme Court of India observed that laxity in investigation causing inconsistencies in the circumstantial evidence as presented by the prosecution may be regarded as fatal, and the court may grant benefit of doubt to the accused. The investigation into a criminal offense must be free from any objectionable features or infirmities which may give rise to an apprehension in the minds of the complainant or the accused. The investigation was not fair and may have been carried out with some ulterior motive. Your Lordship, in the present matter, the trial is vitiated because of the faulty investigation. Your Lordship, if the counsel may be please allowed to screen share the evidences. I request the court master to kindly allow the same. Yes, thank you. Your Lordship, if you may first come to page number 17 of the moot proposition. If you may please refer to page number 17 of the moot proposition that contains the Caesar memo or containing the pen drive of the CCTV footages. Your Lordship, it must be noted that this CCTV footage was one of the prime evidence that was brought forward by the side of the prosecution. Your Lordship, if you may please note that the date of the Caesar memo is 24th of September. Now, if you may please refer to page number 13 of the moot proposition that contains the Malkhana register. Your Lordship, page number 13, 14 and 15, all three containing the Malkhana register, nowhere mention that this pen drive has ever been submitted by the investigating team in the Malkhana. The pen drive was never ever submitted by the investigating team in the Malkhana, and hence there are serious chances of it being tampered. Further, Your Lordship, it must also be noted that there is no road certificate or no reports of the forensic science laboratory report that confirm that this pen drive was ever, or the CCTV footages were ever sent to the forensic science laboratory to see whether they have been ever tampered by the investigating team, and hence there is a serious possibility that the investigating team might have caused disturbance with the pen drive and the footages contained in it. Further, Your Lordship, if you may now please refer to page number 21 and 22 of the moot proposition. Your Lordship, there are various items that are seized on both these pages. Now, the date of their seizure has been mentioned in the moot problem as 16th of December. Your Lordship, but when we move back to the Malkhana report, again present on page number 14, these items have been submitted in the Malkhana a day prior to their seizure, that is 15th of December. Your Lordship, it is beyond understanding how can something that is being seized on 16th has been submitted a day prior to even they were seized. Further, if this sounds to be a bit of apprehending, if you may now please refer to page number 19 of the moot proposition that contains the road certificate. Lordship, if you may please see the date of the road certificate. It shows that it has been prepared on 3rd of October 2019. Now, the items that have been transported in this road certificate contains the items that were seized on 16th of December, which means that those items were transported by the investigating team almost 2 months before they were even seized by the investigating team. Further, then the investigating team cannot claim this to be a typographical error, because if you would now refer to page number 20 of the moot proposition, that contains the forensics, the acknowledgement receipt from the forensic science laboratory. Again, it shows that all of these 8 packets have been received on 3rd October itself. Now, Your Lordship, both the receipt certificate and the acknowledgement receipt confirm that even the items that were seized on 16th of December were transported and received on 3rd of October, which is 2 months prior to even their seizure. Your Lordship, this only and only indicates one thing, that there is something really fishy in the investigation of the present matter. Further, Your Lordship, the whole reliance, apart from the CCTV footage of the prosecution, was on page number 5, second last paragraph of the moot proposition, that talks about the presence of the mobile chats. Your Lordship, it must be noted that the mobile phones, that is iPhone 6 and iPhone 11, of chats of which the prosecution has contended that on the basis of these chats, they are contending that my client was present with the victims. Your Lordship, there is no road certificate or acknowledgement receipt that shows that these mobile phones were ever sent to forensic science laboratory for such retrieval of data. There is no receipt for the same that is available in the present case. Further, these mobile chats and these mobile chats and the data has never ever been submitted before the honorable court. If you may please refer to the last line of the same paragraph, the station house officer, on pursual of the mobile chats depicted, Your Lordship, it is the station house officer that has depicted himself on the basis of his mobile chat that has been retried by the scientist. The counsels for the defense would be highly obliged if the investigating team can all, or the investigating officer, with the help of the prosecutors, can present such chats before the honorable court and show that how they came to such a depiction. But the same has never ever been brought before the honorable court, and hence it again shows that yes, there is something wrong and really wrong in the present matter. Your Lordship, now the last thing, that the counsel was really confused when he was going through the whole report that was submitted by the side of the prosecution. Your Lordship, it made me question all the reports of all the international agencies and all the schools and colleges that are being taught, that states that the population of the country is on a rise, and it is on a serious rise. Your Lordship, if you may please refer to whole of the proposition. The council kept on turning the pages, each and every Caesar memo that has been submitted. Or in all the Caesar memo, the witnesses that have signed were only and only part of the investigating team. There is not even a single witness that has signed any of the Caesar memos, which shows either the investigating team did not want to indulge any independent person in the investigation, or there is no one available in the city except the investigating team. Your Lordship, further, apart from the Caesar memo, there is an absence of various other important documents as well on behalf of the investigating team. First, there is no spot panchanama that has been attached. Second, there is no inquest report that has been attached. Third, there is no arrest memo. Fourth, if you may please refer to that the ABC hospital reports containing the examination of the accused after his arrest showing no injuries on his body has not been again attached. Fifth, as already stated by the council, the WhatsApp conversation and the call records that became the basis of the formation of the raid team for the accused has not been submitted before the honorable court. And sixth, the ballistic examination was even never carried out in the present case. Your Lordship, these are only the few documents that the council has mentioned, as there are many more such documents that are not submitted before the honorable court. Your Lordship, all of this clearly proves that the CCTV footages cannot be relied upon. Further, Your Lordship, if you may again please refer to page number 5 of the moot proposition, the second paragraph. Your Lordship, it must be noted that in the second paragraph, only and only state that in CCTV footage, it was seen and through the call records, it first paragraph, Your Lordship, page number 5, that Sanjay brother Ashu in law, Ashu was found strolling in vicinity of the flat where the incident took place. He was not seen with the victim. He was only seen alone strolling. So the council fails to understand how the defense is coming, how the prosecution is coming to such a contention that there has been a last seen theory can be established in the present case. Further, the location ID charts that is present on page number 5, second paragraph, second line. Ashu's call detail records and location ID charts were scrutinized, and it was found that at 7:59 p.m. he was from ABC Nagar, Delhi. Your Lordship, his mobile chat depicted that he was in ABC Nagar, Delhi. But if you may now please refer to page number 1 of the moot proposition, paragraph number 1, third line. It shows that the dead bodies have been found at Kavi Nagar. These are two completely different locations. And again, the council fails to understand that how on the basis of these mobile chats and CCTV footages, the prosecution has come to the conclusion that my client was last seen with the victim. Further, Your Lordship, at last the council contends that even the evidences that were submitted suffer from a number of infirmities. It is a well settled principle that where the case is mainly based on circumstantial evidences, the court must satisfy itself that various circumstantial evidences form a chain that should clearly establish the facts of the case. In the case of State of Punjab versus Bhajan Singh, on footnote number 33, on page number 22 of the memorial from the defense, the Supreme Court of India held that where there is no eyewitness of the occurrence and the conviction of the accused is sought to be secured on the basis of circumstantial evidences, but these evidences themselves suffer from a number of infirmities, then the accused shall be acquitted. Your Lordship, the council will be following a particular timeline. If Your Lordship may first refer to page number 6, paragraph number 3 of the moot proposition, from the first line, and the council quotes, the station house officer got Ashu's medical done at ABC Government Hospital, wherein there were no injury marks on his body. Your Lordship, now this was the medical examination that was done soon after his arrest. Now, on the same day, Mr. Ashu makes a disclosure statement, which is clear from the next paragraph, as per the investigating team. But now, if we please refer to the next page, that is page number 7, second last paragraph. On 18/12/2019, that is 2 days after his arrest and disclosure statement, Ashu was taken to DDU hospital, wherein his detailed medical examination was carried out. Now, Your Lordship, this detailed medical examination of DDU hospital is present on page number 24 of the moot proposition. Your Lordship, if you please refer to page number 24 of the moot proposition, it shows that there were presence of red bruises found on inner part of right thigh with acute pain. Now, Your Lordship, the contention for the defense was that it cannot be because of a torture that has been done to him in the investigation of the present matter or when he was in arrest, because there was no signs of fever, nausea, or vomiting. They accept that they will only accept the contention that a person has been tortured when it will go to such an extent when the person will start vomiting and will have fever because of the same. The marks on the body are not enough for the prosecutors to accept the contention. Further, they contended that he got such a pain because he was trying to escape when he was taken for the recovery of the country made pistol. Your Lordship, if you may please refer to page number 7, third paragraph, that talks about the whole incident related to recovery of the country made pistol. Now, there is no mention by the investigating officer in the facts or anywhere that my client tried to escape from the arrest when he went for such a disclosure, when he went for such a recovery. And again, there is again no independent witness, because again, even when it was in a public park, the station house officer or the investigating officer of the present matter could not get any independent witness to sign the same. Further, Your Lordship, if you may now please refer to page number 27 of the moot proposition. Your Lordship, in page number 27 of the moot proposition that contains the reports from the FSL. Your Lordship, if you will see carefully the reports, there is an absence of any fingerprints of my client on the knife, the cylinder, the rod, or to be precise enough, on each and every object that was seized before his arrest. The only thing that contains his fingerprints is the pistol, which the counsel contents has been planted by the prosecutor, has been planted by the investigating officer in the present matter. And as there is no fingerprints on each and every object that was seized before his arrest, further, Your Lordship, it must be noted that the pistol was seized from a public park, that too almost after 2 months of the incident. Now, somehow, which the counsel for the defense completely fails to understand, that how has it happened that when a pistol is present in a public park, it has suffered from all the rain that might have taken place, all the heat of the sun and everything, but still the fingerprints were there as it is even after 2 months. And further, it was in a public park, still none of the persons can discover it in this period of 2 months. No one got an attention that a country made pistol is present there in the public park, and it sustained all the fingerprints. Further, Your Lordship, it must also be noted that the side of the prosecution said that if the defense would tell us what has happened to the deceased when he was with the accused, only then they can prove the innocent of their client. Your Lordship, at first, it is not the job of the defense to investigate the matter. It is the job of the investigating team. Further, probably, yes, we would also like to get an answer as to what has happened. But one thing is for sure, that the victim was not present with my client. And the second thing, we would have for sure got to know what has happened to him if and only if the investigation would have been proper in the present matter, and the investigating team would not have been running around to plant evidences for someone really innocent. Therefore, Your Lordship, taking all of these facts into consideration, the only possible conclusion that the council can lead into is that there is a lot to be objected in the present case, and there is no proper evidence that can prove the guilt of my client beyond all reasonable doubts, and hence he shall be acquitted of the charge under section 302 for the offense of murder of Mr. Sanjay and his mother. It was an honor pleading before the honorable court. Your Lordship, now the council seeks permission to call my co-counsel if there are no further questions.
Lord, would you like to ask some questions?
Yes, Your Lordship.
Can I ask question?
Yes, Your Lordship.
Yes. Uh, Mr. Counsel, you are primarily taking advantage of the faulty investigation.
Indeed,
Your
Your
investigation is faulty, so therefore it's a job of the police to unearth the crime. But
Indeed, Your
fact of the matter is, if we see the evidence, your presence is established by two things. First is your hair are found. Your hair is found at the spot, and the timings are also matching with the postmortem report. The time of death is also matching during the period when you are there. And also your fingerprints are found on the country-made pistol, which have been recovered by you, although after 2 months, but from a secluded place in the park, right? It's a secluded place. The word uses secluded place. So there is section 106 in the Indian Evidence Act, where the burden of proving the fact comes on to you when your presence is established at a particular place and those facts are in your personal knowledge. So your statement under 313 becomes very, very important. So you have not proved. You are saying you are simply denying your presence, but your presence is established along with the weapon which has been recovered. So if we ignore the faulty investigation, then the onus comes on to you under section 106 to prove how this incident has happened. So what do you have to say about that?
Thank you for your question, Your Lordship. I understand the concerns of the bench. Your Lordship, first the council will answer the question regarding the presence of hairs Your Lordship, it must be noted.
And just respond in 3 minutes. Let us see in 3 minutes how you can respond to this
Much
question.
obliged, Your Lordship. Your Lordship, first, the hairs that were found. Your Lordship, my client is brother-in-law of the victim, and he has himself stated in his first statement that he called him, which shows that they were in very good terms. So presence of hair does not show that he was present at the time of the incident. It can be that he might have been present before the time of the incident or some days before, and still his hairs would have existed there. Further, Your Lordship, the the location ID charts that are depicted by the pursual of the station house officer. It is the station house officer that has depicted on his pursual that my client was present there. But Your Lordship, there is no evidence, or at first those charts have never been submitted before the honorable court, so that the council can go through them and will have an opportunity to see how such pursual is made. Further, it must be also noted that the investigating officer, as per the last page of the moot proposition, was never brought as a witness before the honorable court to show how we reached to such a depiction that my client was present at the time of the incident. And hence, the contention that the council has raised is that since there are no proper evidences that show presence of my client at the place of the incident, as the both the things that has been stated do not prove the presence of my client at the place of the incident beyond all reasonable doubts, and hence my client wasn't present at that place. Further, Your Lordship, the CCTV footages also show that he was present at ABC Nagar, Delhi, whereas the body has been found from Kavi Nagar, Delhi, which are two completely different locations.
Thank you.
Much obliged. It was an honor pleading before the honorable court. I request to call my co-counsel for the further submissions.
Greetings to the bench. Am I audible, Court Master?
Yes.
Thank you so much.
Yes,
If it
you
may
are.
please the Honorable Court, Counsel seeks permission to begin with the submissions.
Yes.
Much obliged. Your Lordship, this is Counsel number 2 on behalf of the defense. I will be dealing with issue 2, that is whether Mr. Ashu guilty under the Arms Act 1959, and issue 3, that is whether Mr. Ashu guilty under the NDPS Act 1985. Beginning with the second issue, Your Lordship, the council would be submitting a three-folded argument. That is, number 1, Mr. Ashu is not guilty under Section 27 of the Arms Act. Number 2, Mr. Ashu is not guilty under Section 28. And number 3, Mr. Ashu is not guilty under Section 29 of the Arms Act as well. Opening the first fold of the argument, Your Lordship, Mr. Ashu is not guilty under Section 27 because the discovery of the country-made pistol is inadmissible. And even if the discovery is admissible, there is no evidence to prove the unlawful use of the arm by the accused, and there is an absence of ballistic examination to establish a connection between the discovered arm and the shot fired at the deceased. Your Lordship, the discovery is inadmissible because it has been ruled that discovery of a weapon from a public place cannot be admitted firstly. And moreover, in the case of Sudhir Chandas versus State, given on page number 26 of the defense memorial, it was held that discovery made after 3 weeks of occurrence is inadmissible. In the present matter, Your Lordships, the country-made pistol has been discovered from bushes of gate number 2, which is a public place. Moreover, it has been discovered after 2.5 months of occurrence, which is way too much than 3 weeks as ruled in the Sudhir Das case, and hence the discovery is inadmissible in this present matter, Your Lordship. Moving further, if the court admits the discovery, there is no evidence to prove that the accused has used the arm unlawfully. Your Lordship, possessing the weapon and the intention of using it unlawfully together form the essence of the offense under Section 27. In the case of Dayal Singh versus State of Madhya Pradesh, judiciary has opined that is one thing to possess arms without license and quite a different thing to possess the same for an unlawful purpose. Thus, mere possession of arm without license does not constitute an offense under Section 27, Your Lordships. In the case of Murali Jeevanram Sharma versus State of Maharashtra, Your Lordship, which is cited on footnote number 55 in the defense memorial, though it was established that accused was possessing an arm without license, he was acquitted from the charge of Section 27 because there were no evidence to prove the use of that arm by the accused for an unlawful purpose. And significantly, Your Lordship, if no evidence is present to show that firearm in question was used by the person, it would be difficult to hold that those arms was used for an unlawful purpose, and consequently, accused cannot be convicted in such a case under Section 27. In the present matter, Your Lordship, the discovery of the firearm on the information provided by Mr. Ashu neither proved that the arm was used by the accused nor proves that the arm was used for any unlawful purpose. Further, the counsel contends that there is an absence of ballistic report and hence no connection between the empty cartridges seized from the place of occurrence and the firearm discovered can be found in this matter. In the case of Khalak Singh versus State of MP, that is given on footnote number 65 of the defense memorial, Your Lordship, a country-made pistol was recovered, but it was not sent to ballistic expert, and non-examination of pistol by ballistic expert made the recovery pointless, Your Lordship. Moreover, where the accused was found in possession of a country-made pistol, but there was an absence of examination of the pistol by the ballistic expert to prove the fact that the pistol which was recovered was the same which was used for the commission of the offense, the conviction under Section 27 was not justified, and the same was stated in the case of Balveer Singh versus State of Madhya Pradesh as well, Your Lordship. In the present matter, the discovery of the country-made pistol is not sent to the ballistic expert but to a chemical expert, Your Lordship, and the same is clear on page number 7, para number 4 of the moot proposition. In the absence of the ballistic report, it cannot be affirmed if the discovered firearm has been used to murder the deceased, and moreover, it cannot be affirmed if the empty cartridges seized from the place of occurrence are shot from the same discovered arm. Further, Your Lordship, the accused is not guilty under Section 27, Clause 2 and 3. To convict under these two clauses, along with the unlawful use of the arm, it must be proved that a prohibited arm has been used by the accused. Moreover, any arm can be considered as prohibited only when it answers the description under Section 2, Clause 1, Subclause I of the Arms Act. Your Lordship, contrary to this section, if there was nothing on record to suggest that the missiles were discharged continuously on application of pressure to the trigger, and the weapon was to be bolted every time a shot was fired, the weapon would not fall under the definition of the prohibited arm, and therefore conviction under Section 27, Clause 2 and 3 would not be proper. In the case of Subhas Rajkumar Bindu versus State of Maharashtra, cited at footnote number 79 of the defense memorial, it was held where a person is murdered by the accused with a firearm, but was not included in the definition of the prohibited arms, the accused cannot be convicted under Section 27, Clause 2 and 3. And in the present matter, Your Lordships, the discovered arm is the country-made pistol. It is not a prohibited weapon, Your Lordship, and it has to be reloaded every time a shot is fired from it, and hence the accused is not guilty under Section 27, Your Lordship. Now, opening the second fold of the argument, Your Lordship, the counsel contends that Mr. Ashu is not guilty under Section 28. In order to be guilty under Section 28, the accused must have used or have attempted to use any firearm or imitation firearm with intent to resist or prevent the lawful arrest of himself or any other person. And in this matter, Your Lordship, Mr. Ashu neither used nor attempt to use any firearm, not even any imitation firearm against the police when he was arrested on 16/12/2019 from the Vijayanagar market. In fact, Your Lordship, when search of Mr. Ashu and his car was carried in Vijayanagar market, no firearm or imitation firearm was found or seized by the police, and the same is clear on page number 6 of the moot proposition itself. Now, rebutting the argument of the prosecution of Section 28 of the Arms Act, the counsel contends that prosecution in its written submission is widely imagining the facts as there are no scenario in the moot proposition which says that the accused tried to escape the arrest. Moreover, the opposite counsel never stated, neither in the written submission nor in the oral submissions, that the accused tries to use a firearm to resist the arrest, which is the prerequisite of Section 28. And as far as red abuses are concerned, Your Lordship, my co-counsel has proved that it was torture of the police. Further, even if we accept the wild imagination of the prosecution, how is the injury, that is red bruises, present on the inner thigh? If the injury was inflicted to arrest him, it must be on back of the accused legs or hands. How it is present on the inner thigh part of the accused, Your Lordship? Thus, it seems that there is really something fishy during the investigation. Now, opening the last four issue to your lordship, the council humbly submits that Mr. Ashu is not guilty under section 29 as well. Criminal liability under section 29 of the Arms Act 1959 arises when someone purchases arms from unlicensed person or delivers them to the person not entitled to possess the same. The discovery of the country-made pistol on the basis of the disclosure statement from the bushy area in Nehru Park 2 gate number does not validate that the discovered arm was purchased by the accused. The prosecution is just inferring from the alleged possession that it was a purchased arm, but such inference is illogical as no transaction or any other evidence regarding the purchase of the gun has been brought before the Honorable Court as an evidence. Further, delivery means voluntary transfer of possession from one person to another, but in the present matter, Mr. Ashu has not transferred the gun into anyone's possession, your lordship, and hence he is not liable under section 29 as well. If your lordships are satisfied with the second issue, the council seeks permission to begin with the third issue, your lordships.
Yes.
Much obliged.
It's just one question, Mr. Counsel. You are saying section 27, 28, and 29 are not made out because it's not a prohibited weapon. It doesn't, if you see the definition under the Arms Act, you're right. Once you pull the trigger, there should be a continuous flow of
Indeed, your lordship.
And if you remove the finger, then it should stop. So it's an automatic weapon. So can you tell us if you are not charged with, if you're charged with 27, 28, 29, but 25 is made out against you for possessing a country-made pistol, can you be convicted without the charge under section 25 if it satisfies the test?
Thank you for the question, your lordship. Your lordship, the council will be giving a 2-point submission for this question. Firstly, the country-made pistol's possession is not proved at the discovery itself in question. And secondly, your lordship, section 25 is not given under the charge sheet, which is given in the moot proposition, your lordship, and hence that particular section is not made out in this particular case.
You didn't probably understand the question. The question was not big that it's not there in the moot proposition. The question is very direct. If no charge has been framed, can you still be held guilty of that? That's the question. You know, it's no. That's the question. What is your answer to that?
Thank you, your ladyship. Your ladyship, the possession is the criminal liability in section 25 arises regarding the possession of an unlicensed arm. And in this present matter, the possession is not even proved because the discovery is itself in question.
Again, you are missing. The question is that if there is no charge under section 25. Now, if there is no charge, whether you can be held guilty if 29 and 28 fail, 27, 28, 29 fail. Can you be punished? Can you be convicted under section 25 without a charge in that regard?
Thank you for the question, your lordship.
Though section 27, 28 and 29 already framed. This is what question.
Thank you for the question, your lordship. The accused cannot be charged for section 25 because he is not, no charge is formed by the prosecution or the investigation agency for against the accused.
Okay.
All right, proceed the way you want.
Much obliged, your lordships. Your lordship, beginning with the third issue, the council contends that Mr. Ashu is not guilty under section 21, 25, 27, 27A and 28 of the NDPS Act. Beginning with section 21, your lordship, Mr. Ashu is not guilty under this section because firstly, the evidences are tampered and seizure cannot be relied. The white color substance seized from the crime scene and the accused car could not be relied because of the loopholes in the chemical report and the seizure memo. The table provided in the chemical report on moot proposition page number 26, your lordship, it shows different seal of SHO specifically for the batch of cocaine that contains purity. If your lordship may refer to seizure memo of cocaine on page number 11, annexure number 3, and on page number 21, annexure number 11, both these shows the seal of SHO at the time of the seizure, as given on the screen share. But in the chemical report on page number 26, that is annexure number 16, Collie, the Pulinda marked as Q4 and P4, which are the only one which has the purity percentage, has different seal from that of the seizure memo. This shows that after the seizure of the cocaine, the seal was opened, cocaine with purity percentage was mixed, and then it was sealed again by someone. This clearly means that the evidence is tampered, your lordship. Moreover, your lordship, the witnesses of the seizure are policemen themselves, even when the general public was available to sign the seizure report as an independent witnesses. And not only this, but there are no call records or chats between Ashu and Sanjay that prove that my client actually possessed cocaine. And secondly, your lordship, prosecution is manipulating the facts and trying to disguise the honorable court. According to the case of E. Michael Raj versus Intelligence Officer Narcotic Bureau, cited at footnote number 109 in the defense memorial, the amount of cocaine seized that must be taken into consideration must be the pure quantity of cocaine which is present, that is 3.3 grams from the crime scene and 2.5 grams from the car of the accused. And the calculation for the same is given on defense memorial page number 36. Further, the accused cannot be charged for even such a small quantity, as there is no proof that shows that cocaine present at the place of occurrence belonged to accused. And further, the cocaine seized from car of the accused is planted as seal of SHO is fake on the seizure, specifically for the batch of cocaine that has purity percentage, and which can be the only basis on which the accused can be convicted. Also, the seizure is signed by policemen and not independent witnesses, your lordship. Further, the prosecutions stated in their oral submission that consumption of cocaine is proved by the viscera of the accused. But your lordship, the viscera of the accused is not present in this matter, but the viscera of the deceased, who is Sanjay, is present, that was intoxicated and it was not of the accused. And moreover, if the viscera of the deceased was intoxicated, it may be because of the drinks that the deceased Sanjay took, and the bottles are the clear proof of it. Now moving further, moving on section 25, your lordship, the charges require two ingredients. That number one, accused must be in use or control of the house or place where the crime is committed. And number two, accused must have permitted that house or place to be used for committing an offense punishable under the NDPS Act. The first ingredient is not fulfilled because the accused never used any house for committing any of the alleged offenses. Moreover, as far as consuming of cocaine is concerned, there is no evidence or testimony that fulfills the first ingredients except the disclosure which cannot be relied in this matter, your lordship, in the court of law. And second ingredient is not fulfilled, your lordship. Ashu never permitted any person to use any house or to commit any offense. Moreover, even if Mr. Sanjay consumed drugs, it was in his own house, which makes it very clear he does not need to take anyone's permission for the same. And before moving further, the counsel contends that prosecution never touched the second ingredient of this section, and hence they were unable to fulfill it. And consequently, the accused cannot be charged guilty under this section. Moving ahead, section 27, your lordship, the ingredient of this section are given in the case of Gontar Edwin Kitcher versus State of Goa, and it is also cited on defense memorial footnote number 136. The first ingredient is that the person must be found in possession of any narcotic drug in small quantity. Number two, such possession must be in contravention of any provision of the act. And number three, the said possession of any drug must be intended for his personal consumption and not for sale or distribution. The first ingredient is not fulfilled, as there is no evidence to prove that accused was in possession of cocaine found at the place of occurrence. Further, the cocaine seized from the car is planted as the seal at the time of the seizure differs from the seal which the cocaine has during the chemical test. And within this argument, the counsel contends that in the absence of possession, ingredient 2, that is possession must be in contravention of NDPS Act, does not arise at all, your lordship. And with reference to ingredient 3, your lordship, no drug test was conducted by the prosecution to prove that the accused consumed drug. Further, the medical of the accused of both the ABC hospital and DDU hospital clears that no cocaine is found in his body. And not only this, the counsel would like to draw the attention of the honorable court to the fact that no toxicology test is conducted in the present matter, and hence the accused is not guilty under this section. Moving further, your lordships, coming to section 27A, the section punishes for financing illicit trafficking of drugs by any person. And in this present matter, the accused Ashu is not guilty for financing illicit trafficking because he was not engaged in possession, sale, consumption of drug cocaine. And the investigating agency contends that he was arrested with 20 grams of cocaine from the Vijayanagar market, but provides no evidence that whether the seized batch belonged to the accused and how did Ashu finance these activities. Moreover, your lordship, not only this, there is no fingerprint examination done on the seized polythene to come to a conclusion that the seized mixture belonged to accused in this case. Also, the disclosure statement cannot be relied upon because of the element of coercion, which is proved by with the help of the medical examination of Ashu by my co-counsel. And law also says that any confession in front of the police custody is inadmissible. Further, your lordship, no transaction is provided by the prosecution that can prove that my client did finance the illegal activity. Your lordship, the counsel of the prosecutions highly relies on the statement of the accused and state that he was a drug dealer and 2 lakh loan was pending. But the statement cannot be relied as per section 25 of the Evidence Act, and it is given to a police officer during custody. The same was agreed by the first prosecution speaker itself. And further, the chats of which prosecution is relying are not provided as evidence, your lordship. Your lordship, moving further, section 28, the section prescribes punishment for attempt to commit any offense under the NDPS Act. In the case of Jitendra Panchal versus Narcotics Control Bureau, cited at footnote number 164 of the defense memorial, your lordships, the Honorable Supreme Court interpreted the definition of the term attempt. The bench decided the ingredient of the section as intention to commit a particular offense and doing an act to commit such an offense. In the present matter, your lordship, the investigating agency clearly failed to establish that Ashu had any intention to commit any of the offenses for his charge. And there are a number of lacunas in the document submitted and no direct or circumstantial evidence in the present case that completes the chain of the custody. And hence, Ashu has never had any intention to commit any of the offenses, and hence he is not guilty under section 28 as well, your lordship. With this, the counsel submits all the arguments and seeks permission to proceed with the prayer, your lordships.
Yes.
Much obliged, your lordships. Whereof, in the lights of the questions raised, argument advanced, and authorities cited, it is most humbly prayed and implored before the Honorable Special District and Session Court to acquit accused Mr. Ashu under section 302 of the Indian Penal Code 1860, under section 21, 25, 27, 27A and 28 of Narcotic Drugs and Psychotropic Substance Act 1985, and under section 27, 28 and 29 of the Arms Act 1959, or pass any such order that this honorable court deems fit in the interest of justice, equity, and good conscience. With this, the defense rests. It was a pleasure pleading before the honorable court, your lordships.
Any rejoinder they want to give?
My lords, before they start, may I submit some, my lords? The time 55 minutes, which includes the extension, has been exhausted by the prosecution. So my lords may look into that, and my lords.
All right.
Yeah.
With the permission of the bench, may the counsel for state proceed with the rejoinder, your lordship?
You have already, only 2 minutes, we'll give you 2 to 3 minutes.
Do you think you require any rejoinder? Would you like to say something more than what you have already stated?
Indeed, your lordship.
You are going to repeat, then it is no point. If you have some additional points to make, as my lord has said, 1 or 2 minutes you can take.
Much obliged, your lordship. May the counsel proceed?
Yes, please.
Your lordship, the counsel for defense has come forth and put some very fancy arguments without actually giving substantial arguments proving the innocence of the accused, your lordship. Firstly, there are several limitations to the fact sheet which the prosecution has to adhere to, your lordship, and the defense cannot use the same to their advantage. Also, your lordship, regarding the hypothesis provided by the defense, it is not for the prosecution to meet each and every hypothesis suggested by the accused, your lordship. The same was held by the Supreme Court in the case of State of UP versus Ashok Kumar Srivastav. Next, your lordship, the plea of alibi has nowhere been taken by the accused, to thereby showing that the accused was indeed present at the crime scene. Also, no cogent answer and evidence has been produced with respect to the last scene evidence which has been stated by the prosecution, your lordship. Your lordship, page 5 of the fact sheet clearly states that Ashu himself had admitted to the fact that he was staying in an adjoining area and had called the deceased downstairs. Your lordship, next, the nature of injuries are so grave given that they were in the part of vulnerable body part of the deceased, thereby showing that there was requisite mens rea on the part of accused. Further, your lordship, the defense is basing their case entirely on investigational lapses. However, your lordship, investigational lapses have no bearing on the case and cannot be be a ground for throwing away the prosecution's entire case. The same has been given in the case of State of UP versus Jagdeo. Also, change of dates in Malkhana register are a trivial discrepancy and cannot be used to quash the prosecution case, Your Lordship. Same has been given in the case of State of Himachal Pradesh versus Lake Raj. Further, Your Lordship, the Defense Counsel have claimed about the witnesses. However, there are catena of judgments which state that police officials and constables can be taken as witnesses and prosecution can rely on the same. Has been given in the matter of State versus Prakash by the
Speaker 2, team 550, I guess your connection is losing. Speaker 1, please connect with your co-counsel.
Indeed, Your Lordship, with Your Lordship's permission, may the council continue with the rejoinder?
Yes, but your 2 minutes are almost over.
No, it's over. It's over.
Your Lordship, if 1 minute would be permitted, I'll be.
So, but whatever, how do you explain those entries in the Malkhana register? You say it is trivial. How it is trivial? And there are Delhi High Court judgment that Malkhana register, if there is a tampering, or if it creates suspicion, the accused is entitled to the benefit.
Your Lordship, the council understands your apprehension. However, these are investigational lapses. Moreover, Your Lordship.
No, it says manipulation, you see. I think there is a Delhi High Court judgment on this point.
Indeed, Your Lordship. However, Your Lordship, the council in the present case have proved the case beyond reasonable doubt, relying upon the circumstantial evidence present on record. And moreover, Your Lordship, there have been no tampering with respect to the articles which have been seized from the crime scene, and same have been deposed in the forensic report. Hence, Your Lordship, the council would like to rest the case.
All right.
Much obliged, Your Ladyship.
I request to the bench if I can get just 2 minutes for the rebuttal. I will just take 2 minutes of court time for the sir rebuttal.
We can't keep on going like this.
Your Lordship, the sir rebuttal was allowed as per the rules of the
It's
competition.
under the rules, so that
Yeah, we've heard you. Thank you.
Your Lordship, just the counter of the point that have been put by the prosecution.
Your Lordships, am I audible right now?
yes, madam, your colleague has now completed, so it's all right. We've heard you. And you have to remember, we are only testing your advocacy skills.
Yes.
That's the main thing. So you don't have to, we are only testing that.
I completely
We are
understand.
not going to pronounce a judgment on who is right or wrong.
I completely
The
understand.
scope of them.
I completely understand. I was just
So you
following-
don't need to.
Yes, your ladyship. I was just following the rules of the competition, sir. If the court doesn't allow, I'm fine with that. I have no
You
problem.
want to allow him for 1 minute then. The rules permit that. All right, for 1 minute only. Only 1 minute then.
Before the
Madam,
council
you
for,
are already over. Please don't.
I wish to seek an clarification, Your Ladyship.
Clarification for what?
Have the rebuttals been the rejoinder been provided from the prosecution side, because I seem to have
Yes,
lost connection in between.
Your colleague has already done it. That's
Yes,
what.
your colleague has done it.
So the other speaker has done. Thank
All
you.
right, Your Lordship. All right.
Yes, please. Team 510.
Yes.
1 minute. That's all.
Thank you, ladyship. Your ladyship, I will like to start just with a small correction on part of the defense, as the second speaker from the defense stated that the court cannot make additional charges. But as per section 216 of Code of Criminal Procedure, the court has the power to the same. But the contention of the defense was that even the ingredient of section 25 are not met, and so the charge cannot be implied. Further, the trivial discrepancies that the prosecution says that all of these discrepancies stated by the defense are just trivial. Your Lordship, 2 months difference in the seizure and transport, 2 months difference in the seizure and acknowledgement receipt, 1 day difference in seizure and receiving, and further lots and lots of differences. All of these cannot be called to be trivial. The only thing trivial here was the investigation that was carried out by the investigating officer. And thus, with this, the council rests his case. It was an honor pleading before the Honorable Court.
Just to tell you one thing, the question which was put to your colleague was whether you can be convicted in an offense for which there is no charge. Please read section 222. that if an offense which is minor in nature,
Lesser.
the essential ingredients of the offense which is minor in nature are proved, then you can be convicted in that section.
Indeed, Your Lordship, that is what the council stated,
That we wanted to
that
know.
indeed, if the court thinks, the court can add the charges.
Not add.
No, not add.
That-
There is no need to frame a charge for
No,
a
there's no adding the charge, but you can be convicted for a
Yes.
lesser
for
offense.
a
Yes,
That's the
for
point.
Lordship,
That
but
is
lesser
what I understand.
for a lesser
that
offense.
state that at any time before the judgment, the court has the power to
Yes.
add any charges.
Not add.
You are not understanding again.
It's not
You
at
have
the
been
time of
made-
framing the charges. After the trial is over, at the time of judgment, conviction
Indeed.
can be for a lesser of that. That's the point. We were
Indeed,
trying-
council accepts the same. Thank you.
Yes, Saurabh, how do we go about it? Now we send you the answer sheet or we'll get 5 minutes. How do we go about it?
My lords, may send it to the coordinators.
Or can we all, the three of us can discuss and tell you the results?
Yeah,
Yes.
that can be done, my lords.
If
For
we
5 minutes or 3 minutes? Tell us so that.
I think if you can keep others in the lobby, we can
Yes,
discuss
or you
it.
do that.
Yes,
Yes,
surely, my lords. I'll do that.
if we
yes,
can
even
just
that is
ask
all right.
for some feedbacks from the bench, it will
We
be
will do it. Let's first have the.
okay. So shall we go into the waiting room?
Yes, I'm
You
doing
have to
that.
wait. Please wait. All the participants can wait.
Or put everybody else in the lobby so that they don't hear our discussion.
Please, my lords.
Even you have to go.
Yes, I will.
स्टूडेंट्स को अगर कुछ आती है तो आउट कर सकते हैं आउट ही कर दो
My lords, may proceed. I am leaving the room, my lords.
All right. Yes, because you can't.
He is left physically.
Obviously, because he can't. He's the host. He has
Otherwise,
to.
we'll be
One of us has to become the host. Otherwise, he can't control.
Yes,
You can leave for 2 minutes. Come back in 2 minutes. Yes.
Yes, sir.
Sir, बोलो आप.
नहीं आप बोलो. I think speaker 1 in 550 and speaker 1 in 510 were better than the speakers.
The team, we have to give it. They don't need the mark sheet actually. We can just tell them which team. आप बोलो. Team which one? Which team?
Well, I found that that first girl to be quite.
She was very good, no doubt. But what about the team wise? You have to go team wise.
Team wise, I will go with 5-5-5-0. 0-0.
The girls team.
Yeah.
What about you, Vikas?
I think if you see the delivery of the arguments were good for.
Please, Saurabh, leave us for 2 minutes.
Sorry, my lords, the session is live streaming, so my lords, I will request you to.
All right. Okay, then we will have to leave. We will have to leave and decide how do you want us to do?
My lords may communicate over phones, my lords.
All right.
I'll
All right. Then
put in the.
in 5. We should join in 3 minutes then.
Yes, my lords.
All right. We'll leave for the time being.
Yes, surely, my
Mr.
lords.
Pathak, I'll just call you up. All right.
Okay.
Thank you.
Should we leave?
Yes, my lords. You may reconnect later, my lords, after your discussion is over.
Okay.
Yeah. Thank you.
बस एक ही है। अच्छा अच्छा अच्छा, ये पलक के नाम से है। एक मिनट आपको रीनेम कर देती हूँ। रीनेम
पलक के नाम से कैसे आया?
आई थिंक पलक ने लास्ट यूज किया हुआ है।
हेलो,
Namaste, sir.
नमस्कार।
Sir, actually the judges have left to discuss over the marks and everything, so they'll be joining again.
Okay.
Yes, and I have put
Okay.
in
Then
all the
at that time,
participants in waiting.
at that time.
Yes, sir. Sorry, sir.